previously received a copy of the pre-sentence investigation report, correct?
I did, Your Honor.
And I know that Mr. Mercado had filed a pro se motion, which we addressed on the last date. I indicated that if you believe there was a legal basis for it, you could adopt or supplement that motion. Where are we at today in connection with that?
Judge, I have discussed Mr. Wilfredo's desire to withdraw his plea with him. At this point, I have not been able to find a legal basis to either adopt or supplement that pro se motion.
So is there any legal basis for him not to be sentenced?
No, Your Honor.
People move for sentence.
We do, Judge.
I'll hear from the people first.
Thank you, Judge. Before I begin my sentencing remarks, I would like an opportunity to read from the crime victim impact statement, which was completed by Ms. Deborah Munson Cheatham. Cheatham is C-H-E-A-T-H-A-M, the sister of the deceased.
I just ask, as you know, so our court reporter can make sure that she gets everything that he reads more slowly than maybe you might otherwise read.
Certainly, Judge. I'll do my best.
Thank you. Don't worry, I'll stop you if we need to.
Thank you, Judge. This was a conversation had between Ms. Munson Cheatham and the Crime Victims Counselor for the Department of Probation. She noted that it was the holiday time at the time she spoke with probation, and that she was finding it increasingly difficult to think about her baby brother, Robert. She stated while crying that she thinks about him a great deal, but during this time of the year, she reflects back on the times when she and her brother were children and would go sleigh riding. She stated that her and her brother were close, as she often felt that her brother was the only close family member that she had left. She explains that she feels very alone and keeps the sorrow to herself. She further explained that she and her brother lived miles apart and were not always in touch. However, she would keep in touch with him when possible. She explained that her brother did fall on hard times at some point in his life. However, the situation did eventually improve for him. Ms. Munson Cheatham stated that her brother Robert was not a violent person by any means, and that he could actually be considered a very gentle man.
Could you slow down a little, please?
The manner in which the defendant murdered my defenseless brother was vicious. Ms. Munson Cheatham stated that the defendant smashed her brother's face in with cans, stabbed him, and then strangled him with a belt. She stated that her uncle went to identify her brother's body, and her uncle told her that he was glad that she did not have to view him in such a gruesome condition. Ms. Munson Cheatham further explained that her brother's body was in such terrible condition that the family decided that they would have him cremated. Ms. Munson Cheatham stated that she and her brother grew up in a family that had numerous amount of police officers, and she is very grateful to the City of Newburgh Police that they were able to quickly capture the defendant that murdered her brother. Ms. Munson Cheatham said the defendant has anger issues, and he should go to prison for the rest of his life and never be allowed out to be able to kill another innocent person. She further stated that she was informed that he has a history of violent behavior. Therefore, she feels that the defendant shouldn't be given another opportunity to regain access to society. That last statement being one that I frankly couldn't agree with more. This defendant stands before you having pled guilty on September 28, 2018 to the top count contained under indictment 2017-416, the Class A1 felony offense, murder in the second degree. The court, however, should note that this is not the defendant's first felony conviction, but rather his sixth, spanning over 30 years. Additionally, he is a lifetime level 3 sex offender. This defendant is someone who has demonstrated time and time again that he is unable to walk among free men and women or to function in a civilized society. As a result, a severe sentence must be imposed, and in this case, 22 years to life in prison. If I may briefly outline, Your Honor, his felony criminal history. In 2013, he was convicted in Orange County Court of burglary in the third degree and was sentenced to 2 to 4 years in state prison, a case he was on parole for at the time of the instant offense. In 2002, he was convicted of burglary in the third degree and received 3.5 to 7 years in state prison out of the Bronx. In 1992, He was convicted of rape in the 1st degree, as well as assault in the 3rd degree, and sentenced to 4.5 to 9 years in prison, and it is that conviction that forms the basis for his sex offender registration. In 1987, he was convicted of criminal possession of stolen property in the 4th degree and received a sentence of 1.5 to 3 years in state prison. And in 1986, he was convicted of grand larceny in the 3rd degree and received a split sentence involving both incarceration and probation. And his criminal history was very succinctly summarized by the Department of Probation, which outlined in the pre-sentence report that the defendant has been sentenced to jail or prison 12 times in the past. The defendant's age at first arrest was 18. The defendant has been previously arrested 4 times while other charges were pending. He's been on probation 3 times and parole 3 times. The defendant has previously been arrested 8 times while on probation or parole. The defendant's probation has been revoked 2 times and parole has previously been revoked 2 times. On May 23, 2017, as I stated, while the defendant was on parole for his latest felony conviction, he decided that it was Robert Munson's day to die. A 61-year-old man who was simply going to work as a desk attendant at a transitional housing complex at 44 Grand Street in the city of Newburgh. He intended to work the overnight shift, arriving at 11 p.m., a shift that he never survived to finish. There is video of the incident which depicts the first moments the defendant came into contact with the victim. The victim was seated at his desk. The defendant walked past him, as was customary in the transitional housing complex, and the victim never looked up, certainly unaware of what was about to come in the moments after. He was reading a newspaper and drinking a cup of coffee. This defendant went to an area behind the desk, away from the cameras, and returned a short time later with multiple cans of corn contained in a bag which was tied off and used as a weapon. When the victim was not looking, the defendant struck him multiple times with the cans of corn, and thereafter the victim struggled for his life, literally. During the altercation and after being disoriented from being struck by several cans of corn which were full and closed, the defendant got the upper hand on Mr. Munson and literally dragged him out of view of the cameras and to the back area where he emerged from with the cans of corn. And on some level, I'm happy that there was no video evidence of what happened behind that front desk, as it can only be described as brutal, savage, and violent. The evidence showed that the victim was stabbed 7 times in the upper torso using a kitchen knife. He was beaten all over his body and ultimately strangled with his own belt. And if you take a moment to appreciate the violent nature of that act, this defendant severed a leather belt from a 200-pound grown man and choked him with his own belt. I cannot think of anything more savage. The whole murder lasted less than 10 minutes, but the defendant did not flee. He remained at the crime scene, making an ill-fated attempt at destroying evidence, namely removing computer monitors and discarding them out the back of the building, and even at times providing keys at the front desk to other residents of the transitional housing complex while Mr. Munson was bleeding and dying 20 feet away. This defendant showed no remorse in returning and staying at the crime scene. And during that time, and during the 6 to 8 hours that followed the murder, this defendant left his footprints in the blood. He left his DNA on the belt, which was severed from Mr. Munson's waist. He left his DNA on the cans of corn that were used to assault and disorient Mr. Munson. And he also brought Mr. Munson with him back to his room in the form of blood on his sneakers, which were recovered from his room. By leaving Mr. Munson to bleed out, the defendant deprived first responders of the ability to take any life-saving measures. At the time that they found him early the next morning, he was dead on arrival. And to illustrate how little remorse this defendant had, even after the murder and even after destroying the evidence some 8 to 10 hours later, he returned to the crime scene and interacted with members of the City of Newburgh Police Department and also members of the Department of Parole. I would submit to you in an effort to learn information about the investigation. Now, I'm not a doctor, but I did consult with the FBI's Behavioral Analysis Unit in connection with several of the behaviors the defendant demonstrated during and after the crime, and many of these behaviors are consistent with a sociopathic tendency, specifically the unprovoked overkill nature of the murder of a stranger, the presence at the crime scene for many hours following the murder, and returning to the crime scene to interact with members of law enforcement. The evidence also suggests that he went to sleep at some point between the murder and the time of his arrest. When he was finally arrested and interviewed, the defendant admitted to the killing, but even then could not provide an explanation for the same. I think he indicated that the defendant said some words to him, a statement belied by the video, but even if accepted as true, is no basis to kill. Based upon the serious, brutal, and savage nature of the crime, together with the defendant's criminal history, I would suggest to the court that a life sentence is not enough. But since we are bound by the statutory guidelines, I'm asking this court to impose a sentence that ensures the defendant will never walk among us again, a sentence of 22 years to life in prison. Thank you, Judge. As a second felony offender.
For the record, we did allocute him with respect to the prior felony conviction previously, a statement pursuant to CPL 400.21 in connection with his conviction for burglary in the 3rd degree in County Court, Orange County, in the state of New York, on or about May 13th of 2013. Mr. Boyce?
I would just note that at the time Mr. Mercado entered the plea of guilty before Your Honor, this court was fully apprised of the facts and evidence surrounding the details of this case. At the time Mr. Mercado entered the plea, this court promised to cap his sentence at 21 to life, and I would ask the court to impose that sentence at this time.
Mr. Mercado, the law affords you an opportunity to be heard before I impose sentence. You're not required to say anything, but if you do want to say something, now would be the time to say. Is there anything you'd like to say? It is unfortunate, Mr. Mercado, that you've demonstrated that you are a violent recidivist. You are a violent felon convicted of murder and rape, among other felonies. You're very fortunate, which Mr. Rosenwasser alluded to, that there is no death penalty here in New York State, no viable death penalty statute, because this very well could be a case where the people would seek the death penalty and a jury ultimately would decide that. That was the former death penalty statute. The court didn't decide the death penalty, the jury did. Your actions were cold, they were calculated, and they were savage. And your actions have earned you a life sentence in connection with this case. I agreed as part of the plea bargain to cap my sentence at 21 years to life, and that is what I believe your actions have earned you. It's the judgment and sentence this court. You will be sentenced to an indeterminate period of incarceration, the minimum of which will be 21 years, the maximum of which will be life. There's a mandatory $300 surcharge, a $50 DNA databank fee, and a $25 crime victim assistance fee. The aforesaid does constitute the judgment and sentence of this court. Please read his right to appeal.
You have a right to appeal to the Appellate Division, 2nd Department within 30 days, and in addition, upon proof of your financial inability to retain counsel and to pay the cost and the expenses of the appeal, you have the right to apply to the Appellate Division, 2nd Department for assignment of counsel and for leave to prosecute the appeal as a court person and to dispense with the printing. The Appellate Division, 2nd Department, is located at 45 Monroe Place, Brooklyn, New York, 11201.
We're adjourned at this time. give you something that Ms. Polidor submitted to Judge Slobod. Sure why, but I figured I'd let you see it. Obviously, you know that I have to make a copy for the people because it's not important. But I figured I'd